I'm Will Satterfield. I'm the Bureau of Workers' Comp. Now, a quick safety topic for this month is carbon monoxide. Temperature kind of really dropped on us, so a lot of people are thinking about alternative sources of heat, maybe warming their car up in the garage, but the bad thing with that is all that generates carbon monoxide. And actually, the hemoglobin in our blood prefers carbon monoxide over oxygen, right? So it'll absorb all that carbon monoxide and won't take up the oxygen. So what happens? Minor cases, you get dizzy, nauseous. Serious cases, it can be a death. But carbon monoxide, if you start noticing that, and the bad thing is after a certain point, you're going to get bad enough that you don't even realize you have the symptoms anymore. And then the inevitable happens. So be really careful. Some of the different sources can be any really natural heat source, anything that has carbon, natural gas, wood, propane, whatever. But some ways to mitigate the problem, monitor for carbon monoxide. You can get a monitor you can put in your house, in your plant. If anybody has gas or propane powered forklifts in their plant and has a lot of them, now's the time of year when you're going to have your dock doors closed, not a lot of ventilation, so you could have some issues. Keep things clean, maintain any system that uses that type of fuel, and try not to get things too airtight, because that's going to allow carbon monoxide to build up. So we can check for that. We all have CO monitors, so if you think you have a problem, we're not going to come to your house, we'll come to your business, okay? Give us a call. You call your local fire department, power company, if you think you have an issue in your home. But feel free to reach out. So that is it for me, and I believe we're going to go right to Michelle Bach with Coolidge and Wall, and she's going to give us a presentation on My Injured Worker Can't Work. What do I do?
All right, good morning everyone. My name is Michelle Bach, and I'm an attorney with Coolidge Wall. I appreciate the opportunity to speak with you this morning, and I would just like to give you a quick biographical information about me. Some of you I know, some of you I do not. I grew up in Cleveland on the west side, and my dad said I could go to any state school in Ohio, and then he said, how about Miami University? So I went to Miami University, absolutely loved it, had a great experience. I was an English literature major, so I spent a lot of time reading big, fat, heavy books like these. And despite having many, many career options as an English literature major, I decided to move on to law school. I went to the University of Pittsburgh. I'm not exactly sure why, other than the fact that my parents had lived there when they were first married. My mother loved it, was devastated when my dad had a job transfer to Cleveland, so somehow I thought going there was a good idea. I had met my husband at Miami, came back to this area to practice after I graduated from law school. I have been in private practice for 29 years. Every time I have to change the number on that slide, it just shocks me how long I've been doing this. But I am certified as a specialist with respect to workers' compensation defense by the Ohio State Bar Association. My firm is Coolidge Wall in downtown Dayton. As a little fun fact, we're actually the oldest law firm in Ohio. That doesn't necessarily mean that we're the best, but we've definitely been around for a long time, and we are very proud of our long and rich heritage here in the Dayton area. So, my passion truly is representing employers and helping them defend their workers' compensation claims. So we are going to talk about one such topic today with respect to defending claims. And that is what to do when your injured worker cannot work. Obviously, this is very common. If someone has an injury that is significant enough that they cannot return to work, as the employer, you have to make a decision about what to do with this employee. So when you're in that situation, I liken it to being on a three-pronged road. The employer has three options when this occurs. You can pay salary continuation, you can allow temporary total to be paid, or you can offer a light-duty job. So we're going to go through those three options and see how you can manage these claims. The first one, of course, is to pay salary continuation. And I'm just curious how many of you utilize salary continuation as a strategy to manage your claims? Just one poor soul is using salary continuation, or the rest of you just don't want to commit to answer your question in public. Okay, the law provides that you can pay salary continuation, which literally is paying the injured worker their regular wage. You would continue to pay them their regular paycheck, even though literally they are disabled, recuperating, and at home on their couch, doing whatever they may wish. Hopefully, they're legitimately recuperating from their injury. The payment of salary continuation under the law is completely voluntary. So an employer may pay if they wish. They are absolutely not obligated to do so. If an employer wants to pay salary continuation, you of course have to let the BWC know that you are doing that. And in the world of workers' comp, we have a gazillion forms, right? With names that never, ever, ever make any sense whatsoever. So it's hard to remember what the form is. In this particular case, it's called a C-55 form, but it's a form that you submit to the BWC every 45 days. So as to why the BWC calls it a C-55, I guess is just one other way for it to be confusing. The C-55 form has to be signed by the injured worker and by the employer. So it can be a little tricky to get them in to sign the C-55, but that is best practice to do that. And again, you have an obligation technically to submit that every 45 days. So in my 29 years of experience, I've never met a claimant who would refuse their regular paycheck, right? I mean, they're definitely going to be willing to accept their regular paycheck if they're recuperating from a workers' compensation injury. So why would an employer want to continue to pay an injured worker their regular paycheck if they're not working in it, if they're at home? They would be doing that because the payment of salary continuation would not increase their premiums. There are two types of employers. Does anyone happen to work for a self-insured employer? Oh, you do, okay. A self-insured employer pays the cost of their claims directly out of their own checkbook. So if an injured worker has to go to the hospital, have surgery, if they receive temporary total, permanent partial, any other type of benefit, a self-insured employer pays that directly out of their own checkbook. So you would always be paying if they're disabled and unable to work after an injury. For a state-funded employer, however, you pay your premiums to the state of Ohio in exchange for your workers' comp coverage. So this is similar to me having State Farm insurance for my car. Heaven forbid, if I get in an accident after I leave this meeting and I total my vehicle, which, by the way, would probably be covered under workers' compensation, right? Because I'm a traveling employee and I'm here for work, but that's a different seminar. If I total my car as I leave this meeting this morning, State Farm would pay for my vehicle. But what's going to happen to my premiums? If I'm a bad risk and I total my car, they're going to jack up my rates, right? My premiums will be more expensive. So workers' compensation for a state-funded employer works exactly the same way. That's why it's important to be managing the cost when people are injured and off work. So salary continuation could be a method of doing that. So what's the downside of paying salary continuation? You might start to feel like you're just doling out the checks, right? Check after check after check, week after week. The problem is there is no formal means to terminate those payments like there is with temporary total, and we'll talk about that in a little bit. But again, I told you it's voluntary, right? So you could stop doling out the checks anytime you wanted. Let's say someone's off work far longer than you expect, and I get this call all the time. You know, my third-party administrator told me to pay salary continuation. This guy's been off for 6 months. He should have been back to work in 2 months. You know, what are we supposed to do? I'm super frustrated. This is very expensive. Well, again, you can stop that anytime you want, but then they probably will switch over to temporary total, which will negatively impact your premiums. So then you pretty much shot yourself in the foot, right? You just doled out all that cash, and then they switched over to temporary total, and then your rates are going to go up. Well, this sounds a little tricky. How do you decide if or when to pay salary continuation? In my experience, third-party administrators tell every single employer to pay salary continuation every single time. And I think that that is a big mistake. It can be a good strategy, but only in certain cases. I like to tell my HR professionals, you are the boots on the ground. You know your good apples from your bad apples. If you know it's a good employee who will probably be back to work within a reasonable and finite period of time, there can definitely be some cost savings. But if it's a bad apple, or if it's going to be a long period of time, I think lots of employers are just absolutely terrified about the payment of temporary total, which can be detrimental. But sometimes you can get actuarial information to let you know, give you some data as to what the impact will be upon your premiums, and then you can make a more educated opinion about whether you want to start doling out those checks. All right, so your second option is to allow the payment of temporary total. Temporary total is outlined in Ohio Revised Code Section 412356, so that's our statutory authority. Temporary total is defined as the inability to return to your former position of employment. So that is a little bit of a fine distinction. Let's say you work in construction, you break your arm. You can't go back to construction, but you might be able to do something else. But as long as you're unable to perform the job that you were doing at the time that you were injured, you are entitled to temporary total. Temporary total, by the name, is supposed to be temporary, right? But I've certainly had cases over the years where people are on temporary total for long periods of time, months, sometimes even years, if the employer or the Bureau does nothing to terminate them. But it is supposed to be during a finite period of recuperation. The claimant has to show that his or her disability is related to the allowed conditions. We argue this a lot. Let's say someone's claim is allowed for a shoulder sprain, but the medical indicates that they are off work for a rotator cuff tear. The claimant doctors, especially more of the hired gun folks, the claimant attorneys send them to because they know how to, pencil whip the paperwork. Oftentimes they will put the proper ICD code on there, but the office note itself will indicate that they're off for a condition that has not been allowed. So sometimes that can be a defense as well. So the benefit of temporary total is that there's no out-of-pocket expense, right? You're not doling out those checks from your own checkbook. But what is the downside of temporary total being paid? I already told you. It's going to cause your premiums to go up. So you do have to be very careful about the payment of temporary total in your claims. As a general principle, anytime the payment of temporary total or any benefit, permanent partial, wage loss, anything like that is paid in your claim, it will have a negative impact and will increase your premiums. That's the simplified answer, and I'm not an actuary. I already told you I was a lit major, right? So don't ask me complicated mathematical questions. But does it level off at some point? And we'll talk about this in a minute. Like if the temporary total ends, will that impact lessen or decrease? Probably yes. So it's kind of a constant up and down shell game. But in general, you should always be, trying to manage and mitigate your temporary total. And I don't mean to sound too jaded by any stretch of the imagination. Obviously, people legitimately get injured at work every day of the week, but sometimes they don't legitimately get injured at work. And even if it is a legitimate injury, if they're off work too long, the employer should be doing something about that to mitigate the cost. All right, so how can we terminate temporary total? How and when does temporary total end? The law actually spells out the obvious, and that's if someone returns to work. So of course, if they actually go back to work, they shouldn't be entitled to disability benefits. The law also indicates that if their physician of record says that they can return to work. Now, in my experience, someone telling you you can go back to work and the person actually returning to work are two different animals. But the law does say as soon as your doctor indicates on the Medco 14 form that you are released to return to full duty, then your temporary total should end. The third option is if light duty work is made available to the claimant. How many of you folks offer light duty? All right, a fair number. So light duty can definitely be a good cost-saving strategy if it is done properly. In my experience, this is often an area where employers make mistakes just because they're not familiar with it or they're not savvy, or honestly because they've gotten bad advice from someone else and they're not familiar with what the statute actually requires. So, referring to the law here, the Ohio Administrative Code explains exactly what an employer must do in order to properly offer a light-duty job, and it indicates that the offer has to be made in good faith. That doesn't necessarily mean you have to give them something that they like or want to do. I always like to share my example. I represent Meijer, the grocery store, and this was many, many, many years ago. They offered a claimant a light-duty job where they would come in to the seafood counter and count shrimp. I do not know why. I do not know if there's some reason to be counting shrimp. But if you're an employee, I don't think counting seafood is like at the top of your list of desirable things to do. And actually, ironically, they gave that individual a stool to count the shrimp, and he claimed he fell off of the stool. I cannot make this stuff up. All right, so it has to be good faith, it has to be suitable employment, and it does have to be within a reasonable proximity. I have had some claimants over the years argue, you're sending me to a location. I had one woman say that's a mile farther away from my regular location, and that's not reasonable. That argument was rejected by the Industrial Commission. So this is what the statute requires, and then moving on to some additional requirements. You can see in there, there's quite a bit of detail about what you're supposed to do, but the key part is you have to make a written job offer. So how many of you call up your injured worker? Let's say you call up Mary and say, why don't you show up to work in a couple of days? We'll have you count the shrimp, show up at 8 o'clock. I mean, do you call your people to have them show up for light duty? None of you. All right. Okay. Very good. The law does indicate, and I cannot emphasize this enough, that the light duty job offer must be in writing. It has to be in writing. If it's not in writing, it will not constitute a defense to the payment of temporary total. But the job offer does have to meet the statutory requirements. I have a form letter that I freely send to people. My email is on the materials. If you want that form letter, I will be happy to send it to you. I do try to educate people about how to do it properly, and there are certain requirements that have to be met. Lots of times, you have to give at least a brief description of the job. You're going to sit at a desk, answer phones, light paperwork, filing, whatever it might be. Some of the job offers that I see that TPAs give to clients or that employers come up with on their own, it basically says, show up and we'll give you something light to do. I mean, that's not going to fly. You are going to get zinged by the Industrial Commission for something like that. And then I had one client who basically reprinted their whole entire employee handbook in the letter. There was just way too much detail. Just a brief description of what you want them to do is best. I also do recommend that you attach the Medco, literally physically attach it, and that you reprint and reference that in the letter, and or you can say, if you repeat exactly what the restrictions are. I mean, if the job is outside of the restrictions, I mean, the hearing officers are super, super picky about that. All right. Okay, that looks a little wonky on my slide there. Not sure what happened, but the other option for terminating temporary total is to obtain an MMI finding. MMI standing for maximum medical improvement. And just keep my picture in your mind as we go through the definition, because we're going to try to get our claimants, just visualize them on the top of that plateau is our goal. Well, what does the law say about maximum medical improvement? It does define it as, again, the language sometimes being a little wonky, but if you can demonstrate that an injured worker has reached a treatment plateau, and then you have all that gobbledygook afterward, which basically means they're about as good as they're going to get. They're not getting significantly better in terms of their medical condition, and they're not getting significantly worse. So their condition has essentially leveled off or hit that plateau. This does not mean that they're 100%. They could still have pain and problems. They could still have difficulty with their range of motion. They could have other residuals from the injury, but they're about as good as they're going to get. Okay, so you can get an MMI finding. How do you actually get an MMI finding? You can obtain a defense IME. We're all about the acronyms, right? The independent medical examination. So the law provides, with respect to every contested issue, allowance, additional allowance, the payment of benefits. An employer can always get an IME with a doctor that they know and trust, a doctor that they choose or their attorney or their TPA chooses for them. So it's very important that you select the right doctor for that exam, someone with the appropriate credentials, and someone who can give you an MMI opinion. I kid you not, one of the experts that I use all the time, his real name is Dr. Stephen Wonder. As to why you would name your child Stephen if your last name is Wonder, I have no idea. But we use him all the time. He's a physical medicine and rehabilitation specialist. So let's say you have someone who's been off work for an injury for a very long time, or even what should be a reasonable period of time. You may be proactively getting those appointments. That's what I do. The doctors, their schedules fill up quickly. So when an injury occurs, or let's say someone has a rotator cuff surgery or a medial meniscus surgery, I will reach out to my doctor and say, about when do you think there'll be MMI? And if they say 4 to 6 months, 6 to 8 months, whatever it might be, we snag those IME dates, and then we plug them in. We send the notice and we send them out for the MMI exam. So if you get an opinion from Dr. Wonder or someone else saying that the person has reached maximum medical improvement, you can file a motion like this, and after you file a motion, you would have a hearing before the Industrial Commission, and then hopefully the hearing officer would agree that they've reached MMI and they would terminate the benefits. So that's something you should proactively be doing all the time. All right. If you're lucky and they get incarcerated for some reason, that is also a means of terminating temporary total. That doesn't happen very often, but if they are incarcerated, they can't get TT. And then the last means of potentially terminating temporary total is if you can show that they have voluntarily abandoned their employment, which literally, as the meme shows, and I get this all the time, and I'm sure you folks do too, I'm not quitting, I'm just not showing up for work anymore. Those situations are fairly common. This area of the law is actually super complicated. I don't know if any of you have dealt with it before, but it comes up frequently in my practice, and I'll give you a couple of examples, cases that I'm actually working on now, where I will be arguing this principle. So what exactly is voluntary abandonment of employment? I showed you before Ohio Revised Code Section 412356, which is a statute, and Ohio Administrative Code that told us what to do for the light duty job offer. Another way that the law develops is what we call through case law. So 100 years ago when I went to law school, we literally had big, fat, ugly books, just like those in the picture. And of course we had a ginormous hard copy library with all of these books. Back then, we had to learn how to literally figure out where to go in the library to get the exact book to read the case that we were looking for, whatever the topic might be. And so now, what do people do to find this information?
Wikipedia.
I'm sorry, Wikipedia.
Yes.
Well, that's,
All people question.
I was thinking Google, but okay, yes. You know, and of course there are online search tools like LexisNexis and Westlaw and things like that. So yes, it's much, much easier for the young folk nowadays, you know, who have computers and can easily have this information at their fingertips. But what exactly are the cases or the case law? I mean, this is what is so fascinating about the law, is that it literally develops from real people, real stories, real employers, real claimants, and then as those cases weave their way through the courts, you get these decisions. Now, the interesting thing about workers' comp is by statute, the allowance of a claim, so let's say the allowance of a claim for a rotator cuff tear, for a psychological condition, for anything like that, any medical diagnosis, that can be appealed to the Court of Common Pleas, to our state trial court. Have any of you been a juror? I'm just dying to be one, and I never ever get selected. It's like my life's dream to be one. And of course they probably kick me off anyway, but I just never get selected. So the Court of Common Pleas, you can either have a jury trial or you can have a bench trial before a judge. All other issues in workers' compensation by statute are appealed by way of what's called mandamus, which is a fancy word meaning you're seeking a writ or a legal document to compel someone to do something, and that goes up through the Court of Appeals. So anything other than allowance would include temporary total, right? So temporary total decisions can be challenged through the Court of Appeals. So they go from the Industrial Commission to the Court of Appeals and sometimes all the way to the Supreme Court of Ohio. And then these cases, if they go to the Court of Appeals, they're written up in these books. So we're supposed to figure out what the law means by looking at these cases, or at least initially, that's how the law of voluntary abandonment developed. The general concept being that if something voluntary occurs, you are not entitled to temporary total. So if the claimant does something that would break the chain of causation, they shouldn't get the TT. Temporary total, of course, is to replace their wages while they're off and recuperating, right? I mean, if you break your arm and you can't work construction for 8 weeks, that's when workers' comp should step in. The employer should either pay you your paycheck or you should get the temporary total, because otherwise you're out of luck and you're not working and you need the income. Well, what if my construction worker, let's say Bob, does something else and that's why he's not working? Now, what could he do what other types of things could happen where he would not be working? There's all sorts of things. I'm sure we'll think of some. We'll go through some here in a minute. But if it's involuntary on his part, that he's disabled and his disability is related to the injury, he should get the TT. So the way the law developed initially was looking at all these funky fact patterns, right? Again, because these cases are about real people in real situations and all the wonky things that they do, which is what makes the law so incredibly fascinating. You know, lots of times people get fired for all sorts of reasons. Well, if you got fired, you know, and that's why you're not working and you don't have wages, should you still get TT? Well, does it depend upon pre-injury misconduct, like if you did something bad right before the injury happened, or if your misconduct caused the injury? I don't know if you heard about that horrible case, the Kentucky Fried Chicken case, with a young teenager. And I'm telling you, I have so many claims with the young teenagers. I always talk about, I represent the YMCA of Greater Dayton. And, you know, the Camp Kern, I'm telling you, I've just seen the goofiest, weirdest stuff that young camp counselors do at Camp Kern. They're constantly getting injured. And I'm sure that's because their frontal cortex of their brain, right, is not developed until age 25, and a lot of them just haven't gotten there. So the Kentucky Fried Chicken case, unfortunately, this young teenager was told to clean the air fryer, or the fryer for the chicken, and he almost dumped some water in it. You know, it's a pressure cooker. So the manager told him, no, that's super dangerous. Don't put water into a pressure cooker. And the kid went ahead and did it anyway. And it blew up and severely, severely injured him. Terrible, terrible injury that this young man suffered. Well, you know, so his employment was terminated because he basically blew up an air fryer and blew himself up. I mean, should that prevent him from getting temporary total? Sometimes, so it can either be pre-injury misconduct, it can be something they did that caused the injury that could lead to the termination. They could do something after the injury, any type of misconduct that might be unrelated. Or, I mean, lots of times people violate written work rules, right? I mean, I'm sure all of you, do you have a no-call, no-show policy? People have to show up for work. And if they don't show up for work, they just have to give you a call. I mean, I see this all the time. People no-call, no-show. And then the employer appropriately terminates their employment because they have a written work rule. So a lot of these scenarios developed, and this is how the case law developed. And then the legislature decided to literally wipe it all out. So if you've ever heard of Louisiana Pacific, is a very well-known case that talks about the written work rule, and if you violate that, that can be a defense to temporary total. Legislature wiped it all out here recently in 2020. And they enacted this new statute to guide us through these situations when people are seeking temporary total. So the new statute basically says, you can see all the gobbledygook that they wrote in it, but it essentially says if you can't work because of your injury, you should get temporary total. And if you're not working for reasons unrelated to the injury, you shouldn't get temporary total. Well, that sounds really simple, right? That sounds like that makes a lot of sense. But what do you do if it's both? Lots of times it's both. So let's see what happened. We've had just a handful of cases since the new statute. The first one is this AutoZone case, which involves a claimant who was injured in June of 2020, which is actually before the effective date of the new statute. So he's injured in June. That new statute I showed you goes into effect in September. This claimant did not miss any work from the injury because the employer offered light duty, and we talked about that. A few months later, after the injury, he's involved in a verbal altercation at work, and so he's fired. He does not return to work in any capacity for anyone after his termination. He actually gets unemployment because it was found that there was no reasonable basis for the termination. And then he undergoes surgery for the allowed conditions, okay? So he's injured, he's on light duty, he's fired for this verbal altercation, then he undergoes the surgery. So should this guy get temporary total? Who thinks that he should get temporary total? I mean, is he off? Or if we have questions, we can talk about it more. Do you have a question, or you're the only brave soul answering my question in public? People who know me know that there's going to be some forced audience participation. So that's going to be this slide and the next two, okay? So, I mean, I guess if you're going to analyze this, you have to look at the statute, right? The first question is, this guy is injured before the statute goes into effect. So does this statute even apply to him? One would think no. And the court said yes. Agreed. I know, lots of times things do not make sense. So this statute applies to every injury, even before the statute goes into effect. Okay, so the court decides that. And now the next question is he not receiving wages because of his surgery related to his injury, or because he got fired because he got in the verbal altercation? Well, it's both, right? And the statute doesn't explain that. So, since no one will respond to my question about whether you think he should get it or not, he gets it. Well, I think the facts are that he got unemployment and then he was going to get temporary total. So, yeah, he gets it. Now, under that old law that the legislature wiped out, you would have had like a Louisiana Pacific violation of a written work rule defense. You could say we terminated him because he got into an altercation and we have all of our documentation. But here, even though the guy was fired for an altercation at work, he's going to get his TT. So let's look at another case that has been decided since the new statute. This gentleman had a very severe lower back injury, but way back in 2011. Over the years, he required a lot of surgery and extensive care, so he was off and on temporary total at various times. We had talked before about an MMI finding, right? That cuts off the TT and is an official declaration by the Industrial Commission. This guy has physical and psychological conditions allowed. There was never a finding of MMI on the physical, but there was on the psychological many years later in 2019. This guy did not work for 9.5 years after his injury. He did not work. But his claim remained active because he was treating, and then he got a second lumbar spine surgery in December of 2021. So 11 years after this injury happened, he's seeking TT from the date of his surgery forward. So do you think this guy should get temporary total? It's like a bad bar exam question, right? Nobody wants to answer it. I mean, is he off work because of his surgery and his injury, or is he off work because he chose to be unemployed for 9.5 years and he never got a job in the interim? Again, nobody wants to commit to anything. They gave it to him. They gave him the temporary total. So even if you're replacing wage income, even though the guy hadn't worked for 9.5 years. I mean, these decisions are very negative for employers. What are we supposed to do with this? It's a problem. And the last case, in the Hyman case, the claimant was injured. He was off work for about a year. His claim again was allowed for physical and psychological conditions. This guy was eventually released to return with restrictions. The employer gave him a light-duty job. The claimant decided not to accept the light-duty job offer. Something about, I have no experience working in an office. I don't want to work in an office. He gets a job with a different employer, works for them for a few weeks, but then he's laid off due to COVID. After he's laid off, he seeks temporary total related to his original injury. So again, injured, rejected the light duty, gets a job with a different employer, laid off due to COVID, and now he wants TT relating to his injury. I mean, should this guy get temporary total? Does he not have wages because of his injury? Who thinks he should get TT? It doesn't specify, but I believe that it sounds as if it was a legit offer. Anybody else think he should or shouldn't? That's a trick question. That's a bad question. Does anybody else think he should not get the temporary total? Should not. And actually, this time they agreed. He shouldn't get it. But how are these distinctions being made? The other thing I should have told you, the AutoZone case, the first case that caused kind of all of this mess, that was a decision from the Court of Appeals, has been appealed to the Supreme Court of Ohio, has been pending, waiting a decision by the Supreme Court for a year. Do you think all of us could not do something for a year and still have our jobs? So we're all kind of on pins and needles waiting for them to decide. So I guess just a couple other, for example, I have a claim for the YMCA, a young kid who jumped off of a piece of playground equipment and had a knee injury. So the Y offered them a light duty job. Of course, I told them how to do it. They did do it properly, and he turned it down. And then he quit, saying basically, there's no way I can possibly come back to this job, which literally, he worked for after school care, so literally sit there and watch the kids run around. sit there and play games with them, and he turned his nose up at this job. And then he quit. Now he has to have surgery on his knee. So, of course, now he's going to want temporary total. I mean, is he going to get it? I mean, I'm going to have to figure these cases out, right, and go to an industrial commission hearing. We're going to be duking it out about whether he should get it or not. It's confusing. Attorneys are supposed to be advocates for their clients. And so, I mean, I'm going to fight to the death for my client and do everything that I can to be an advocate for them, and claimants counsel are going to do the same. Claimants counsel are also incredibly motivated because they're paid on a contingency fee. So they get a third of any benefit check their client gets. So if these people get temporary, it's kind of at the heart of it. And again, I mean, we are advocates, and that's their job. But they are paid based upon getting a third of whatever benefits they help their clients achieve. So if they help their clients achieve temporary total, they'll get a third of their check. But I do have another quick one, case for a different employer where they properly offered the light duty job. He accepted the job. So I think that helps. You accepted it. He could have continued doing the light duty job, but for the fact that he worked third shift, and the supervisor found out that he was literally leaving the facility for hours at a time. You're not supposed to leave at all. You only get a half an hour for lunch. And they have cameras in the parking lot. You can kind of see his car come and go, and he would ditch for 2, 3, 4 hours during the shift. So the employer fired him. Well, now he wants temporary total from the date that he was fired forward. I mean, should that guy get it? I mean, I wouldn't think so. But we'll see how it goes. The Bureau also has this amazing program now that if you want to revise your handbook, you can have that reviewed by legal counsel of your choice and get $2,000 a year to have an attorney review your handbook every year. I mean, so basically the Bureau is going to pay your attorney fees to write your handbook. So that's another way to go about it. Thank you so much. Appreciate it.